Good afternoon, everyone. My name is Peter Neufeld. You may have seen me before. I'm a partner at the firm Wagner Sidlowski LLP. I'm here co-chairing this Lunch and Learn series on issues in family law and estate law, along with my colleague, Professor David Friedman, who, if you were at the last event, you would have seen him host at that event. The subtopic for today is an update that we're going to be providing on joint family ventures. We have two papers that were prepared in advance of today's seminar on this topic, and the PDF copies for those papers can be found in the Zoom chat. I'll ask Maddie to add those to the chat so you can click on it and download them. The certificate of attendance will also be posted in the chat momentarily for you to download. Always remember that you can't go back to the chat after you log off. So make sure you download this as you get it so you don't forget, so you don't log off and at the end of the seminar and you've forgotten to download these really helpful papers and, of course, the certificate. A few housekeeping notes. Please always have your microphones muted at all times unless you're asking questions at the end of the presentation. Which, again, after you're done asking those questions, we ask you to mute yourself. You can ask questions in the chat, or if you're so bold, you can raise your hand or just chime in with a question orally. We're happy to field either way. We've got two presenters today. We have Gregory Sidlowski and Hillary Engel. Greg is very experienced litigator. He's certified by the Law Society of Ontario in civil litigation. He's a partner at Wagner Sidlowski. He appears before all levels of court in Ontario, and he has represented clients before the Supreme Court of Canada. He's also very well experienced in, of course, state matters. Joining us from the family law side is Hillary Engel from Epstein Cole. Hillary's practice encompasses all aspects of family law, including marriage contracts, cohabitation agreements, custody and access, support claims, division of property, and complex financial issues. So thank you both for being here today. We really look forward to this. Of course, thank you to the sponsors. You make this event free. In particular, thank you to Scotia Wealth Management, the B'nai B'rith, Epstein Cole, Concentra Trust, BMO, Private Wealth TD, Torkin Mains, Solos Trust, as well as Weir Folds. If you've enjoyed our seminar, we ask you to consider making a donation to the B'nai B'rith Canada Food Program. If you haven't already, or if you want to do it again, please do. That'd be great. And then I'll be having Maddie add the link to make that donation also in the chat. On that note, we have Elite Mannheim from the B'nai B'rith. She is the manager of legal affairs at B'nai B'rith Canada. She's here with us today, and she wants to talk for a few minutes about the organization and its charitable work. So Elite, I saw you earlier, just when we started. So I know you're here. Go ahead. You have the floor.
Thank you. So good afternoon, and thank you for having me. Actually, in each session, we're talking about a different aspect of B'nai B'rith and our current advocacy and legal initiatives. So today, I would like to speak to you about the new policy we introduced. So actually, we introduced this last week on September 26th. B'nai B'rith Canada announced that it has developed a robust policy framework to help school boards across the country respond to the unprecedented crisis of anti-Semitism in their district since Hamas's terrorist attack on Israel last October 7, 2023. This is why B'nai B'rith, the continuing occurrence of anti-Semitic incidents at school across Canada demonstrate that the existing policies and framework in place to protect students and educators from racism and hate, and to ensure that all members of our school communities are made to feel welcome and included, are insufficient. This is why B'nai B'rith, the voice of Canada's grassroots Jewish community and the nation's most senior human rights organization, introduced the B'nai B'rith policy for combating anti-Semitism in schools, in short, PCAS. The policy notes that it is paramount that students learn that anti-Semitism or hatred of any kind is unacceptable in their foundation school years. The policy's purpose is to ensure that the school environment is free from anti-Semitism and to provide Jewish students with support in expressing their cultural, religious, and historical identity. Moreover, the policy is designed to ensure that Jewish members of our school communities are adequately included in existing DEI, EDI framework. My apologies. Adopting the policy would demonstrate schools' commitment to combating anti-Semitism as both a form of prejudice and legacy of colonial oppression, as well as represent a commitment to upholding the values of truth, justice, and equity for all members of school communities. The framework is shared with school officials across Canada, is meant to serve as a counterpart to B'nai B'rith policy for combating anti-Semitism on campus, PCAC, which I discussed 2 weeks ago. A similar policy B'nai B'rith recently introduced to help university address the anti-Semitism on their campuses. B'nai B'rith release of PCAS comes as the Toronto District School Board, TDSB, faces an investigation for allegedly allowing staff to bring students to an anti-Israel rally during school hours. As per B'nai B'rith, Director of Research and Advocacy, anti-Semitism driven by racial ideologies is increasingly becoming a problem in elementary, middle, and high schools. School boards, such as TDSB, need a better definition of anti-Semitism to improve their existing anti-hate policies, to ensure they include the hate being faced by Jewish individuals. I'm sorry. The purpose of PCAS is to further protect the rights of Jewish students and the educators to freely express their cultural, religious, and historical identity without fear of discrimination, bias, or exclusion. I will add the policy to the chat shortly. Thank you for having me. And for those who observe, happy Rosh Hashanah.
Thank you so much, Ali. We're going to start off the main part of the presentation now. Greg Zidlowski is going to start. Hillary Engel is going to follow, and then it's going to go back to Greg. So Greg, you can start it off. Take it away.
Thank you, Peter. Good afternoon, everybody, and thank you for attending. Today's seminar is on a particular area of unjust enrichment law that was created to deal with situations where an unmarried couple works together to generate wealth, but where on a breakup of the relationship, one person stands to benefit disproportionately from that wealth. So this category of unjust enrichment is referred to as the joint family venture. I will discuss the concept generally, and then Hillary will take us through a roadmap applying the joint family venture principles. And following that, I will go back into some of those principles in a little more detail if time permits. So the concept of unjust enrichment is well known among lawyers, where there has been a benefit conferred by someone who has suffered a corresponding detriment, and where there is no juristic reason for the enrichment, then the court can grant relief to remedy the unjust enrichment. A straightforward example is where two people who are not married buy an asset together, for example, a home, but only one person's name is put on title. The non-owner has contributed to the purchase price of the home, likely contributed to the mortgage payments, the property taxes, and the other carrying costs, but does not own the property. If the couple splits up, or if the legal owner of the property dies, then the person who contributed without their name being on title will not have any automatic entitlement to recover an interest in the property. If the couple had been married and they divorced, then there would be an equalization of net family property. Similarly, if the couple had been married and the spouse that owned the asset died, then the surviving spouse would have the benefit of the Family Law Act election, which was covered in a previous seminar, or the surviving spouse would have the benefit of the laws of intestacy under the Succession Law Reform Act, or at least a right to a preferential share of the estate. But for unmarried domestic partners, the non-owner contributing partner needs to rely on the common law principles of unjust enrichment in order to make a claim to get compensation for their contributions. So going back to the simple example of a couple that both contribute to the purchase of a home, but where title is taken in only one name, the unjust enrichment analysis leads to a finding that the legal owner of the property received a benefit because the costs of purchasing and maintaining the property were contributed to by another. The person contributing suffered a corresponding detriment because they were contributing to the costs, even though his or her name was not on title. And unless there was some contract or other legal justification for one person getting a benefit to the other person's detriment, then the court will step in to remedy the unjust enrichment. And Hillary will discuss some of those remedies in more detail shortly. But that brings me to the joint family venture. A problem arises when we aren't just looking at contributions to a single asset, or where the contributions are not clearly linked to a specific asset or group of assets. In addition, in many circumstances, there will often be difficulty determining how to quantify what compensation is appropriate. Is it simply the value of the money or the services contributed by the non-owner? What if the asset has gone up in value? Does the contributing partner get to benefit from that increase? These questions often arise when dealing with situations where an unmarried couple works together to accumulate wealth over a period of time, and where that wealth is held in only one person's name or disproportionately by one person. So this problem was addressed in the 2011 joint decision of the Supreme Court in Kerr and Baranow and Baranow and Seguin. And since that time, it has been used by courts across the country. It has been the subject of a lot of commentary, and it has shown its importance, not just in family law, but also in estate litigation. And that's why we are addressing it today, to bring a little bit more visibility and understanding to the concept. So when dealing with unmarried domestic partners, the court came up with a more flexible approach to deal with unjust enrichment claims relating to what the court described as joint family ventures. And the court held that a joint family venture will arise where there's evidence to support four different categories. First, there is a mutual effort by the couple to work together toward a common goal or goals. Second, there is economic integration between the couple. Third, there is actual intent to share the wealth that they were building with each other. And fourth, whether they have made decisions or sacrifices to prioritize the family. Now, the court noted that these categories are not a checklist of conditions. There is always flexibility, but the court is to analyze those factors in determining whether a joint family venture arises. But the overriding goal is to address situations where the contributions of a couple to this joint family venture over time have resulted in an accumulation of wealth, and where a breakdown of the relationship would leave one party with a disproportionate share of that wealth. And now I invite Hillary to take us through a roadmap addressing these types of claims. Hillary.
Thanks very much, Greg. So as Greg mentioned, I'm going to be talking a bit about a roadmap as to how you actually pursue these claims. And it's gone through in more detail in the paper, one of the papers that you've been provided in the chat. And I have to give credit where credit is due. The paper was written for a prior program by two of my colleagues here at Epstein Cole, Christy Warren and Rosalind Cho. So thank you very much to them. It's a great practical resource when you're advising clients on these claims. So as Greg mentioned, a joint family venture is really a remedy for unjust enrichment. You'll find some case law where courts have looked at whether a joint family venture occurred when they're determining if there was unjust enrichment. Under Kerr, that's not the right place for the analysis. It actually occurs once you're at the stage of figuring out a remedy for an unjust enrichment that has occurred. So we start then with determining whether there has been unjust enrichment. And as Greg mentioned, the key things that we're looking for there are that the defendant was enriched, the claimant suffered corresponding detriment, and there's no juristic reason for that enrichment. When you're at that preliminary stage, you want to give some consideration to a couple of things. First of all, limitation periods, always important when you're talking about any type of claim. And secondly, as to whether the parties are married. These claims predominantly occur with couples that are not married because of the options that are available for married couples under the Family Law Act. And if a spouse dies, as Greg mentioned, under estate litigation statutes. So if you are dealing with a case where the couple is married, the claim for unjust enrichment isn't completely ruled out by the court, but it's unlikely that you are going to be successful because of what the Family Law Act is able to do, and specifically claims under Section 5(6) of the Family Law Act, which of course allow you to claim an unequal division of net family property in one party's favor. And that can a lot of times help address any unfairness as a result of what you're seeing, as opposed to claiming through unjust enrichment. So once you have established that an unjust enrichment has occurred, you need to look at whether monetary damages will be sufficient to address that. The remedies for unjust enrichment are restitutionary in nature. So you want to be able to repay the unjust enrichment or reverse it in some way. And the first remedy looked at always is a monetary remedy as opposed to a proprietary interest. And it is only when monetary damages would be insufficient that the court will look to other proprietary remedies, including constructive trust claims. I'm not going to go into detail here about constructive trust claims because we're focused on another form of remedy. But when you're looking at determining whether monetary damages are not going to be sufficient to address the claim, you look at whether there's a good probability of recovery if the monetary damages are actually going to be paid. And for example, that could include things like the defendant is insolvent, they're in arrears of support, they have a history of not following court orders. Those are the types of things that courts have considered relevant to that question. And then there is some, there's the other reason is that there may be additional reasons to grant a proprietary interest. That's what the court says in Kerr. And there's some case law that says that if there isn't sufficient evidence at a trial to quantify the monetary damages, that a constructive trust interest may be available. I wouldn't recommend that strategy because there is also case law saying that claimants shouldn't be rewarded for failing to come forward with, for example, a current property valuation or something like that at trial. So if you've established that a monetary award is sufficient, then you get to the question of how you quantify how much that monetary award should be for. And there are two approaches to this. The value received approach, which is also called fee for services. And that really looks at the value of services provided by the claimant. So in a very simple example, if there is a house that's owned together and one person replaces the flooring on the first floor, how much would it have cost to hire a contractor to do that work? And maybe the claimant should be paid that amount. The alternative approach to quantifying monetary damages is the value survived joint family venture approach, which of course is what we're here today to talk about. So that looks at the value of the property in light of the contributions. In the example I just gave, how did the value of the property increase as a result of the fact that there were new floors, which were provided by the claimant, and maybe they also paid for some of the materials necessary to do that, and increase the value of the property in a quantifiable way. Under this method of calculation, the value survived joint family venture approach, you're looking at the share of the accumulated wealth proportionate to the claimant's contributions. So it's not automatically, I replaced the flooring, I'm now entitled to 50% of how much the property increased in value. That's not the analysis. It's far more fact specific than that. And it really involves a detailed understanding of the services provided and the value and how they impacted any increase in the accumulated wealth. So if you have established that the value survived joint family venture approach is the appropriate way to quantify monetary damages, I'm skipping a step, which Greg will talk about more, but I'll just touch on briefly. In order to prove that that is the correct approach, you need to show that, of course, the parties were engaged in a joint family venture. That's a question of fact. You're looking to the four factors that Greg talked about earlier: mutual effort, economic integration, actual intent, and priority of the family. As I mentioned, these are very fact-specific claims to make, and they're very resource-intensive as a result. So if they were engaged in a joint family venture, is there a link between the contributions of the claimant and the accumulation of the wealth? So this is where you're drawing the connection between the value survived in the asset or assets and the value received. So if you, and Greg, as I mentioned, I know that's like the kind of meat of the analysis, but Greg's going to talk a little bit more about that. So I'm not going to go too much into it. But if you are successful in establishing that there has been a joint family venture, you need to actually figure out what the amount of monetary damages that your client will receive will be. In order to do that, you look to the respective contributions of both parties in determining the claimant's proportionate share. So this isn't an exact science, and it's not a minute examination of the give and take of daily life. Because you're dealing with domestic relationships, courts have found that generally benefits are conferred mutually. It's a two-way street that people are receiving and giving benefits, different forms of labor, economic, childcare, all sorts of different responsibilities that people divide up in their domestic relationships. And that is looked at when you're quantifying. It's both parties. Because you're looking at both parties' contributions in determining the claimant's proportionate share of the increase, that's going to happen naturally. So we know that there's no presumption that it will be shared equally, but the obvious question is, how do you actually quantify what the percentage is? Generally speaking, what happens in the case law is that courts they say, we looked at this factor, we looked at this factor, I considered this factor, I considered this, and then a percentage is effectively pulled out of a hat. I was joking with a colleague before this presentation about really spending a lot of time talking about this and saying you could consider this and this and this, and then at the end of it, flip a coin. Because it's very difficult to predict, which of course makes it very difficult for you to advise your clients. But that's one of the things that you have to explain to them in pursuing one of these claims, is it's difficult to know what the court will actually do when it comes to figuring out the percentage. Whatever share you're arguing for, you want to focus on what both parties contributed, as I mentioned, and monetarily and otherwise. So if they bought material for the flooring, of course, that's relevant. It's also relevant if they did some of the labor themselves. It's also relevant if they were primarily doing childcare while other renovations to the property were taking place. All of those things can be relevant, but you want to use that and frame that as a way to support the suggested sharing that you are putting forward. So as I mentioned in the paper, the roadmap is gone through in more detail as a step one, if yes, this, if no, that. So it's a very helpful practical resource. But for now, I'm going to turn it back over to Greg to discuss in a little more detail actually establishing the joint family venture with respect to the 4 factors that I mentioned.
Thank you, Hillary. So going back to those 4 factors, the first is mutual effort. Mutual effort concerns whether the domestic partners worked collaboratively toward common goals. Now, factors that have been mentioned in the case law include making joint contributions, contributions to a common pool of resources, all to achieve common objectives. Also, pooling of effort and teamwork to work jointly toward mutual goals. The use of the party's funds for family purposes. One party contributing to domestic affairs so that the other party may pursue activities in the paid workforce. These factors are not fixed, they're not exhaustive, but those are some that have been identified. For economic integration, the more extensive the couple's financial integration, the more likely that they will be determined to be in a joint family venture for common objectives. So relevant considerations for economic integration include having a joint bank account, using it as a common purse, sharing of expenses, the collective and mutual contribution to a common pool of savings, perhaps directed at the overall welfare of the family. And then there's the actual intention of the parties. The court held that in considering whether there is a joint family venture, the actual intentions of the parties must be given considerable weight. So, for example, if the parties make it very clear to each other that they are not sharing, that their respective assets are not going to be jointly owned, that nobody else is going to have an interest in their respective assets, or they're not going to be shared in any way, then the court will give weight to that It isn't necessarily determinative, of course, because you might have situations where one member of the couple takes advantage of that, but the court will give it weight. But generally speaking, the court is going to consider what the parties have said as well as their conduct in order to determine what their intentions are. And there are a list of factors that the court has provided. Obviously, anything that suggests what the intention of the parties was and whether it was to share their wealth jointly, that would be key. But also conduct that shows that the parties intended the domestic and professional spheres of their lives to be part of a larger common venture. Whether the parties accepted that their relationship was equivalent to marriage. Whether the parties publicly presented themselves as married. Whether they hold joint title to property. What their plans are for their property on death. If they have wills indicating that the parties were going to leave their property to each other or some share of their property interests, that can suggest a relationship that's more akin to marriage. The court will also look at the stability of the relationship, as well as the length of the cohabitation. And in fact, there is a recent case from 2022, which is dealt with in the paper that we submitted. It's the A and Y decision of the Ontario Superior Court. Now, that case did not find a joint family venture, even though there was some measure of sharing of financial resources. There was a joint bank account for some common expenses, and the couple had a child. But the court noted that the properties that were in dispute were considered to belong to one of the people. He alone managed them. He was responsible for them. They were regarded as his investments. The money that went back and forth between them was characterized as borrowing. It was repaid, it was tracked. And both parties participated in the domestic responsibilities. But more significantly, the court made a point of noting that when it comes to intent, people can choose to live together and have children together, but not marry and not share property. So the court was saying that it will give effect to a couple's intentions. And if those intentions are what's mine is mine, what's yours is yours, well, then absent other competing policy objectives, that's what the court is going to enforce. So the mere fact that a couple lives together with a child does not establish an intention to start a joint family venture. Now, the last factor is whether the couple has prioritized the family. And what the court is looking at there is whether they have prioritized the family in their decision-making. Has there been detrimental reliance on the relationship by either party for the sake of the entire family? Examples that the court has taken into account include whether one person left the workforce, the paid workforce, to raise children, so that the other partner can devote their attention to their joint goals of making money, investments, whether one party has foregone a career or academic advancement for the welfare of the family, relocating for the benefit of the other party. So those are factors that the court will take into account in determining whether the couple has prioritized this common good in order to find whether there was a common intention for this joint family venture. Now, if the court determines that the couple has accumulated wealth as part of this joint family venture, and that one of them will benefit disproportionately from the joint pool of assets on a breakup or death, then, as Hillary said, the court will grant a monetary remedy to reflect, quote, the share of the accumulated wealth proportionate to the claimant's contributions. And as Hillary mentioned, determining what the respective parties contributed is not simple. It is going to require evidence, and it's not entirely clear how the court will deal with that evidence. But you have to remember that this is an equitable remedy. So the court is looking to achieve a fair and equitable result. And to a large extent, that's going to involve the exercise of the court's discretion in determining what that fair result is going to be. But the importance and the usefulness of the joint family venture analysis is that you aren't limited to the old fee-for-service quantum merit calculations. You don't have to show with scientific proof, well, I provided these services to this family objective, and I should get X dollars per hour, and I spent this number of hours. You don't have to do that. You also don't have to jump through hoops to convince the court whether you should get just the value contributed or the value that is survived. And as Hillary mentioned, those are very significant differences. And it used to be a very significant argument in unjust enrichment cases because the difference is very meaningful. You might contribute $50,000 to a house, and in the grand scheme of things, that $50,000 might not be a huge proportion of the value of the house. But if in the time that you have contributed that amount, the value of the house has gone up, well, then it makes a very big difference if you are talking about $50,000 simply absolute quantum, or $50,000 toward a house that was worth $500,000 that's now worth $1 million. And using the joint family venture analysis allows you to bypass a lot of the old law that really hamstrung the courts in trying to determine what the appropriate amount in damages would be. The court instead can skip that and simply look at the claimant's proportionate share of the accumulated wealth. And by accumulated wealth, we're automatically in the value survived approach. And by determining the proportionate share, the court is making it very clear that it is not a situation whereas, as the court described in Kerr, you have competing quantum merit claims, where each person is trying to outdo each other by showing their respective contributions. Now, as Hillary mentioned, the calculation is not going to be exact. And the court is not going to expect some sort of forensic accounting to trace how the couple used every dollar, who did what and when. The court, it's very clear from the law, has shown an intention to maintain its flexibility. Its flexibility to consider how the couple functioned, how they contributed towards this joint family venture, and then to come up with an award that is fair in the circumstances of that particular case. Now, in the paper that we submitted, we include a whole bunch of cases to show how the courts have dealt with the issue more recently and how they've applied it to different types of joint family ventures. Whether those joint family ventures involve collecting and managing real estate, or even collecting credit card rewards. There is, as I said, a lot of flexibility in how the court can approach these issues, but not just the issues, how it can approach what is actually comprising the joint family venture. And those cases are very helpful to show the extent that it allows a fair bit of creativity to try and achieve an equitable result when it's not necessarily clear how one person's contributions can be linked without any kind of doubt to a specific asset. Instead, the contributions are linked to this objective, a common objective that was to benefit the family and accumulate wealth. So at this point, I think we can go and address questions. So why don't we do that?
Great. So, as I indicated before, you're welcome to put your questions in the chat, or if you have any questions that you just want to vocally ask, now's your time to do it.
I had a question.
Sure, yeah. Ms. Batra, go ahead.
My question was, what is the limitation period that applies in respect of joint family venture claims, and what limitation periods should all practitioners be cognizant of?
Hillary, do you want to take that?
Sure. Great question. So if you are, if the claim is with respect to real property, then the 10-year limitation period applies, with a couple of caveats. If it's a joint family venture claim, of course, your claim is with respect to monetary damages, and therefore it's a 2-year limitation period. And if your claim is with respect to real property that is owned by an estate, then the 2-year limitation period is also going to apply, as opposed to the 10 years. So you really need to understand what you're asking for, and who you're asking for it against, to make sure that you're not running afoul of the limitation periods.
I think it's important to note, whether your claim is for a proprietary interest in land. If you can make that claim, even if the court winds up awarding damages in lieu of that proprietary interest, you can rely on the longer limitation period. But if your claim is for compensation, if it's against a trustee, if it's just to get your fair share for your contributions, you need to expect that it's a 2-year limitation period.
We've got a similar question here. The question is, when dealing with real property, what is the interplay between a joint family venture and a resulting trust claim? More specifically related to looking at the value survived. Do you think either of you could address that question?
So they can both be applied. If you have a situation, though, where there's a resulting trust, generally you're going to be putting that forward first. It's a more clear-cut remedy. The tests are well established. It doesn't require the same discretionary approach. If your resulting trust argument fails, you can always fall back on the joint venture argument. So I think that when you're approaching your case, you have to, figure out what is your best argument, and you pursue that. But if you can make the case for both, well, then you make the case for both.
There's, one question that comes to mind for me is that you both have sort of addressed that the purpose of a joint family venture claim is to, in part, simplify or get past, I guess, some of the prior jurisprudence that made it difficult to quantify these claims. But as well, you've indicated that it's sort of a complicated thing, and at some points you might need to just flip a coin. So let's say I'm a client that has gone and read one of your blogs. They talk about joint family ventures, and I'm pretty sure that I've got a great claim for a joint family venture, and I'm going to be insisting that my lawyer pursue that. Put yourself in those shoes, that you're in the boardroom, you're hearing from your client or potential client about this potential joint family venture claim. What's some of the advice generally that you'd be giving to them?
Sure. I can start if you'd like, Greg. So one of the things that is important to remember about these claims is because they're so involved factually, they're very expensive to run. And when I'm talking about these claims with a client, I really need to make sure that they understand the costs involved, and we're looking at what their claim may actually be worth, because sometimes it may be smaller amounts of money that are an issue, and if you're going to have to go into a full analysis with respect to the parties' mutual contributions to the relationship, especially if it's a long-term relationship, the legal fees associated with that are going to be significant. And sometimes there's a better way to get the result that the client wants. Depending on the facts, sometimes spousal support can help address some of the perceived unjust enrichment or unfairness or unequal means of the parties at the end of a relationship. So that may be a way to address some of that. And I think this also relates to the prior question with respect to resulting trust. That, as Greg said, that's a much cleaner claim to run. So when you're having kind of the initial conversations with a client about these types of claims, I really think you have to be mindful and advise them about what is actually involved in pursuing this, and see if there are other ways to get at what they actually want that may be less involved from a legal fee perspective.
But at the end of the day, if you have the facts, or arguably you have the facts to pursue the claim, you're going to include it. Just because it does get around some of the other problems that have historically presented themselves for an unjust enrichment case. But it doesn't, and it shouldn't be your only cause of action if you have additional causes of action. For example, in the estate litigation context, if you were a dependent, then you're going to make multiple claims. You're going to claim dependent support. You're going to claim your contributions to a joint family venture, and let the facts come out, and then you see where you stand.
Here's a question that just came up. It's more of a planning question. How do you plan around a claim for joint family venture? What else can be layered into estate planning that can bulletproof the estate from this claim for joint family venture?
Well, I think if you're an unmarried couple and you're concerned about your assets being subject to a claim after your death that it was part of a joint family venture, your best option is to negotiate a contract, a cohabitation agreement that sets out how you are going to deal with the assets. Otherwise, based on the case law, you have to make your intentions clear. You have to make it clear with your conduct as well. If you don't plan to be sharing assets as part of a joint venture, then don't share them during your cohabitation. So you unfortunately have to be mindful of these things and plan accordingly.
Here's a question. If the party who suffers the detriment in a joint venture, so it's a victim that's seeking additional damages through a joint family venture claim, if they're the victim of domestic abuse, does that change the calculus in any way? Is that a factor, to your knowledge, that the courts will consider? I know from my perspective, that's something that is thrown into arguments sometimes for dependent support. But would that be something that would be relevant to a court's determination of determining whether there's the existence of a joint family venture and how much compensation should be awarded?
Hillary?
I haven't seen it as part of this analysis. I mean, as Greg mentioned, you're usually running this claim at the same time of other claims where that may be more relevant. But if your question is it going to increase the proportionate share that your client may be entitled to, without more facts, it's hard to say. But I would say that fact on its own of the existence of an imbalance of power or that there were intimate partner violence issues won't in and of itself equate to a greater proportionate share for your client.
I think you have to go back to the factors that the court considers. The mutual effort is not necessarily going to be impacted by that, whether there's economic integration. Again, if there's dependence, then that would probably assist your argument. The intention, if they're building wealth together, then whether there is, violence or an abuse of power, that could explain why title to assets was held in only one name. So it might affect how the court looks at the intention. Was there an intention to have a joint family venture, or was the holding of title signaling an intention that there wouldn't be? So if there's abuse, that could, I'd say, counter that intention. And then whether you've made decisions, or sacrifices to prioritize the family, I could see it coming into play there as well. But none of these factors are determinative. It's just what the court will consider in the analysis.
Well, thanks very much. If there's any other questions, feel free to raise them now. Otherwise, we'll wrap up today's seminar. There's one last question here. Question is whether the factors to consider for resulting trusts and for joint family ventures can override a cohabitation agreement.
Depends on what the cohabitation agreement says. Usually cohabitation agreements will have a release of equitable claims. So it depends whether there's a release of equitable claims in the cohabitation contract, or specifically what the terms are if they're dealt with in there.
Hey, well, thank you very much, both Greg and Hillary, for the presentation. Excellent jobs today, very informative. And thank you, especially to everyone who's attended. This is going to be the end for today's Lunch and Learn seminar. Thank you for attending. Again, before you leave, the certificate of attendance can be found in the chat. The papers are there. Download it all. Again, consider making a donation to the B'nai B'rith. We look forward to seeing you at our next seminar. It's going to be on the treatment of trusts in equalization claims. That's going to be on October 15th, 2024, and it will be chaired by David Friedman of Wagner Sidlowski and Christy Warren at Epstein Cole. And if you haven't registered yet for that program, there's a link in the chat that you can click on to register. So thank you very much for attending, and we'll see you in a couple weeks.